Ms. Mites, you will be providing her with a copy of the motion for summary disposition, correct?
That's correct, Your Honor. Can we obtain a new hearing date today, or should I call into the court for that?
I'll give you that
Okay.
October date, please. The last one we had was October what?
14th.
Okay. I'm gonna give you the same date as the other case, October 14th.
And will it be 2 o'clock again?
Actually, I'm gonna make it at 2:30. We'll see you then.
Thank you. Just, I'd like to confirm I had the zip right, 48104.
Yes, ma'am.
Okay. Thank you.
Thank you.
Thank you very much. Have a great day.
Thank you, you too.
Thank you.
LAFCU, ma'am, Miss, I'm gonna butcher that. Esquion?
Ashon.
Ashon. Thought I
Thank
would.
you, Your Honor.
Which matter? Is that the matter you're on here?
I am plaintiff's attorney for LAFQ.
Okay. ALFCU versus Roger Roper, 21C 1146. You may enter your appearance now.
Sorry, Your Honor. Jordan Ashon for plaintiff's attorney for LAFQ, P number 84339.
Thank you. Mr. Roper, how are you today?
I'm not good. I'm sitting in here looking at y'all.
Oh,
My
wow.
health is okay.
Your health is okay?
Yeah.
We're causing you that much distress?
Yeah.
Oh,
This is the situation. I know. Do y'all want to hear what's going on?
it's your motion to set aside the default today, sir.
My motion.
I'm sorry?
I'm in West Willow and they have that plane thing going on today. Well,
Yes,
they
they do.
practicing.
Yes, they are practicing.
Blue
Angels.
Yes, the Blue Angels. I co-signed a loan for my son, my stepson, and he apparently skipped out on me and the loan. So now I'm stuck with it. But my understanding was that if they came and got the car and sold the car, I would be responsible for what was left after they sold it. That was my understanding. That's first. Secondly, I wasn't even warned about the first court hearing. I was on vacation on the first court hearing.
Your Honor, if I may.
All right, just 1 second.
Okay.
So, sir, you're here, you filed what's called a motion to set aside a default. And so there are, with that motion, you have to prove 2 things. 1, that there's good cause, and 2, you have a meritorious defense. So those are the 2 things that have to be shown in this particular motion. Did you file this yourself or someone else filed this for you, sir?
I filed it myself.
All right, now you may go on, Ms. Ashton.
Yes, Your Honor. We did file a response, and part of what Mr. Roper just explained is let me back up. He was served with a summons and complaint by personal service on May 3rd. He failed to respond or file an answer to that complaint, which sounds like all of the defenses he is now claiming should have been in a answer, and he failed to do so. So after 21 days of service, we filed a default judgment. His claim that he missed the first court date is there was no first court date because there was no answer filed to initiate a court date. He does not show good cause as out of town to visit his grandkids, and missing a court date is just, as I explained, there was no court date, and also he has already admitted to co-signing on the loan, so therefore there's no meritorious defense or good cause as to why the default judgment should be set aside.
Now, in response to what she's saying, you guys said that y'all came out here and had someone 6 foot tall, 200 pounds sign something. One, I'm in a wheelchair and I'm barely 4.5 feet tall. Two, I'm only about 140 pounds. So therefore, whoever you had signed whatever they signed wasn't me. So therefore, whatever I'm talking about, I missed because you didn't give me any notice. Would you please read your paperwork? I've been in a wheelchair for 20 years, paralyzed from the waist down. I'm in an electric wheelchair, 140 pounds, and I'm probably 4.5 feet tall. I'm in 140 pounds, not 6 feet tall, 200 pounds.
Your Honor, may I respond?
Yes, you may.
I assume the paperwork he's referring to is the proof of service. We don't have anything indicating that he's in a wheelchair. Also on the proof of service,
Correct.
signed by,
Mr. Roper, please let her finish her statement.
signed by Jim Marker, the process service, says he is in his 40s, 5'10", 200 pounds. So this doesn't say he's 6 foot. And I mean, there was no mention with or without a wheelchair. He also, I'm not sure if he was referring to him signing any paperwork as if, you know, like a personal affidavit, but there's no signature by him either way.
So that's my point. I did not get any notice. I don't know what I need to send in showing you I'm in a wheelchair or what I need to show you, but my point is you didn't give me any notice. I don't know who signed what, but I wasn't here to sign anything and was not notified about the last court date.
There was no signature required by you.
Right, stop arguing.
Sorry,
That's enough.
Court date. I'm sorry, it's not, well, whatever it was a notice for me to appear or whatever. I'm not good with whatever's going on. This is the first time this ever happened to me. It's not like I'm in the courtroom every day like the young lady is. So I don't know all the lingo or what's going on, but I know I wasn't there the last time I was supposed to be, or I didn't do something when I was supposed to.
All right.
So I tried to take care of it this time, and that's why I'm here.
All right. Thank you, Counselor. Thank you, Mr. Roper. Mr. Roper, just so that you are clear, Counsel is right. You don't have to sign for a document in order to be personally served. And secondly, once service is made, it is incumbent upon the person who was served to actually file an answer. If an answer is not filed, then a default can enter. Now, Ms. Ashion, Mr. Roper is absolutely correct. This document here says that they served someone who is a Black male in their 40s, 5'10", 200 pounds. And that is what I get from what's written on that. It at least creates a question of fact as to whether or not he was actually served. So that is a question that this court has. You have the option, ma'am, to bring in your Mr. Marker to explain what that means at the bottom of that document, if you so choose to do that. But at this point in time, it appears to me that there's certainly a question as to whether they served the proper person. If he has not been served, then he would not have an opportunity to file an actual answer. As to the meritorious defense, I believe that although he may have admitted that he signed a loan, there's still a question of fact as to how much would have been owed after that car was actually sold. So that does present a meritorious defense as to at least the amount of money that is in question in this case. So that's where I am on this today.
May I?
Yes,
Okay.
ma'am.
So would we be able to reserve him? My question would be that the summons has expired on 8/3, so maybe get an extension of the summons date to properly serve Mr. Curtis. And I would also like to confirm, I guess, his address and just make sure we are getting the correct person. Or I could also reach out to the process server and try to get a better affidavit description, although this is the one that he has. I'm not sure if he'll recall on that date. So I think the best course of action would be to reserve Mr. Curtis. if that's what the court would desire.
His name is Mr. Roper.
I'm sorry. I'm sorry. I'm looking at a different file on my computer and I'm looking at his correct file on my, I'm sorry.
All right, thank you. Well, Mr. Roper, I'm gonna grant your motion to set aside the default in this case. I just, it's very troubling what we have here versus who he is. So first of all, let me swear you in, sir. Mr. Roper, raise your right hand. Do you swear firm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Sir, I'm looking at your little teeny arms over there. It looks like you
Correct.
probably do weigh about 140 pounds.
Correct.
So is it your testimony here today that you only weigh 140 pounds?
Yes, ma'am.
And how long have you been in a wheelchair, sir?
Approximately 20 years.
All right. I'm gonna set aside.
I can send in doctor's note if I need to.
I understand, sir. I believe that you're in a wheelchair and that your weight is about 140 pounds. The affidavit in this case, well, the notation on this proof of service shows a black male 40s, 5'10", 200
Your
pounds.
Honor, I'll be 50 on the 21st of this month.
You're still in your 40s though.
Oh yeah, well, yeah.
I don't understand what the other part says. Don't have hair. I'm not sure what that even means either, but yep, you got plenty of hair. So, you know, I'm willing to set aside the default. On the other hand, Ms. Ashion, I don't think you need to reserve him. He is present. He's aware of it now. What I need you to do is provide him with a copy of the complaint in this particular case. Okay.
I can do that. Would by first class mail, Your Honor, or how would you like me to?
How would you like to receive this complaint, Mr. Roper?
What's going on now, Your Honor? May I ask? I don't even know.
Well, you're being sued based. Well, you know what's going on. You're being
Yeah,
sued.
well, I know I'm being sued, but what do you mean receive a complaint? I already know that she's suing me. I need her to...
Did you actually get the complaint? Is what I'm asking about.
Oh, well, she can send it to me in the mail.
Okay, thank you.
She got my address. She gave the right address.
So then you can send that to him in the mail, and then we will deal with the actual case. I'll give you a pretrial date.
So I gotta go back. I gotta come back to court.
That's what you came to court to do, to set it aside so you could deal with it on its merits, right?
Right.
All right. So yes, you got to come back to court.
So how can they sue me for the entire loan when they took the car and sold the car and they told me that they told me whatever they sold the car for, I would be remainder for what's left between that and the loan.
It sounds, well, I don't know. I haven't, it looks like the loan balance and the repossession costs. Was this vehicle sold?
It was, Your Honor. The difference in the loan amount and let me see here.
Yeah, your loan balance, sir, initially was $8,033. So they're suing you for the balance, the $5 grand.
Okay, now I'm on Social Security disability and I'm getting $1,000 a month. So I'll wait until we go to court.
You might want to call them up to talk to them about this matter to see if there's a way that you can reach a resolution with them or not. That's up to you. It's Ashion's office.
Well, that's what my problem is. They could have did that before we even came to court.
Okay.
They never even contacted me about this situation. They just automatically want to go to court.
September 23rd, 2021 at 2:30 p.m. for pretrial.
Your Honor, if I may just ask, so it's his verbal argument, his response, or are we having a pretrial in the event he files a written response?
I'm sorry. Yes, oh, so you need to file a written response to the actual answer. If you don't, then you can be defaulted again. So you need to respond to their actual complaint. You need to file an answer.
Before they sign, before I come back to court.
Correct. You have, once they've served you, she's serving you by mail. It'll say on that date, the date that they say that they served you. You have 21 days from that date in order, was it 28 based on 28 days from that date in order to actually respond. Okay.
Yes, ma'am.
All right. Thank you.
Thank you.
You're
Thank
welcome.
you, Your Honor.
Thank you. Hello. Court is in recess on Zoom. We will continue our hearing